Okay. Good morning, everyone. My name is Előd Bartis. I'm PhD student at the University of Debrecen and teaching assistant at Sapientia, Hungarian University of Transylvania. I would like to thank you for the opportunity to be here and speak about some constitutional issues of the Romanian Civil Code. I will speak about the admitted exceptions of unconstitutionality regarding to the provision of the Romanian Civil Code. First of all, I will clarify what is the exception of unconstitutionality. According to the Romanian constitution, there are two ways to review the conformity of legal provision with the constitution. One is the objection of unconstitutionality when the constitutional court adjudicates the constitutionality of laws before promulgation. And second, the exception of unconstitutionality when the constitutional court adjudicates unconstitutionality of laws and ordinances raised before courts and courts of commercial arbitration, and on the exceptions of unconstitutionality raised directly by the advocate of the people, otherwise say ombudsman. The subject matter of the exception of unconstitutionality must be a law or an ordinance which is in force or produce legal effects after they came out of courts. It is relevant in the settlement of the case, and the legal provision has not already been declared unconstitutional by the court. In the context of exception of unconstitutionality and fundamental rights, I must mention two provisions of the Constitution. Article 20, which confers priority of the international treaties in matter of fundamental rights, and Article 148, which confers priority for the founding treaties of European Union as well as the other mandatory community regulations. When the question is the non-compliance with the EU laws, the Constitutional Court can apply provision of the EU law in constitutional review. From the entering into force of the Romanian Civil Code in 211, were raised a total of 41 exceptions of unconstitutionality, out of only two were admitted. In the remaining time, I will present these two decisions. The first decision is decision 534 of 18th July 2018 regarding the exception of unconstitutionality of provision of Article 244, paragraph 2 and 4 of the Civil Code. The paragraph 2 of the article states that marriages between persons of the same sex concluded abroad by Romanian citizens or foreigners are not recognized in Romania. Paragraph 4 states that the legal provision relating to freedom of movement on Romanian territory by citizens of the member states and European Economic Area shall be applicable. Briefly about the factual background of the case. Mr. Common, a Romanian citizen, and Mr. Hamilton, an American citizen, were married in Brussels in 2010. They wanted to settle in Romania, which is why Mr. Common requests for the Belgian marriage certificate to be registered at the Romanian embassy to Brussels, but the request was rejected. Mr. Common and Hamilton contracted the General Inspectorate for Immigration and asked if Mr. Hamilton, a non-EU national, in his capacity as member of Mr. Common's family, could obtain the right to reside lawfully in Romania for more than 3 months. The answer was no, because under the Romanian Civil Code, marriage between people of same sex is not recognized, and the right of temporary residence in Romania could not be granted on grounds of family reunion. In 2013, Mr. Hamilton and the ACCEPT Association filed a case against the General Inspectorate for Immigration and the Ministry of Internal Affairs, saying that they and other homosexuals are generally discriminated on the grounds of sexual orientation as regards the exercise of the right of free movement in the European Union. In that dispute, they raised an exception of unconstitutionality of Article 277 of Romanian Civil Code, and they argued that non-recognizing in the connection with the exercise of the right of residence, marriages between persons of the same sex legally concluded abroad constitute the infringement of Article 4 of the Constitution on unity of people and equality among citizens, Article 16 on equality of rights, and Article 26 on personal and family privacy. They also claim that Article 8 and Article 14 of European Convention of Human Rights and Fundamental Freedoms were violated. The Constitutional Court suspended the main trial and sent several preliminary questions to the European Court of Justice regarding to the interpretation to be given to several terms of the Directive 38 from 2004. The main question was, does the term spouse in the directive include the same-sex spouse from a state which is not a member state of the European Union, when the marriage with the European Union citizen were lawfully concluded in the member state, the question two was, if the answer to the question was is affirmative, does the directive require the host member state to grant the right of residence in its territory for a period of longer than 3 months to the same-sex spouse of a citizen of the European Union? And the third question was, if the answer to the first question is in the negative, can the same-sex spouse be classified as any other family member or a partner with whom the union citizen has a durable relationship? The European Court of Justice answered this question by the judgment of 3rd June 2018 in Judgment Common and others. Related to the first question, the European Court of Justice firstly clarified that the directive specially mentions that spouse is a family member, and the term spouse used in the directive refers to a person joined to another person by the bond of marriage. The term spouse is a gender-neutral term and may therefore cover the same-sex spouse of the union citizen concerned. The European Court of Justice also stated that the relationship of homosexual couple may fall within the notion of private life and that of family life. The conclusion of European Court of Justice was that refusing the member states to entry into and residence in their territory a third country national in these situations, by the reason that national law not allows marriage by persons of same sex, interfere with the exercise of the right to move and reside freely in the territory of member states, conferred by the Article 21, paragraph 1 of Treaty of the Functioning of the European Union. The effect of such refusal is that such an union citizen may be denied the possibility to returning to the member states of which he is national together with his spouse. Other two very important consideration of European Court of Justice must be mentioned. The European Court of Justice state that member states are free to decide whether allow or not marriage for persons of the same sex, and that obligation for the member states to recognize a marriage between persons the same sex from granting the free movement of EU citizens does not undermine this institution of marriage in member states, does not undermine the national identity, and does not pose threats to the public policy. These concerns were submitted, by the way, by the Latvian, Hungarian, and the Polish government. After the decision of European Court of Justice, the Romanian Constitutional Court pronounced its decision and, in a sense, repeated the considerations of the judgment common and others, and stated that Article 7 of EU Charter, Article 8 of the European Convention of Human Rights and Fundamental Freedoms, and Article 26 of the Constitution of Romania on protection of fundamental right to private life and family life were violated. The Constitutional Court, with majority of votes, declared constitutional the Article 277, paragraph 2 and 4 of the Civil Code, to the extent that they permit the granting of the right to reside in the territory of Romanian state under the condition provided by the EU law to dispose of same-sex marriage concluded or contracted in member state of the European Union. This is a so-called interpretative decision in which the Constitutional Court declares the unconstitutionality, but in a certain interpretation of the text. In this way, the text is saved in the sense that it can still be applied in the obligatory, mandatory interpretation established by the Constitutional Court. As a decision, as a conclusion, this decision did not override the term of marriage provided in the Romanian Civil Code. It just stated that the same-sex marriage is legal concluded in the member states should be recognized only in context of the free movement of EU citizens. Also, this decision of Constitutional Court has a historical relevance because this was the first occasion when the Romanian Constitutional Court referred to the European Court of Justice for preliminary ruling. The judgment of the European Court of Justice was mostly welcomed by the European community. The second decision about I want to speak is decision 601 on 16th July 2020 regarding the exception of unconstitutionality of the provision of Article 164, paragraph 1 of the Civil Code, which regulates the adjudication of incapacity. The Article 164 states that the person who does not have the necessary capacity of judgment to look after her or his own interest due to insanity or mental retardation will be adjudicated as incapacitated. This is substitution. This is a substitute regime. So that a person's rights and obligations that have been adjudicated as incapacitated will be exercised only by a legal representative, regardless of the degree of capacity of judgment of the person concerned. The author of exception of unconstitutionality argued that the institution of adjudication of incapacity operates with a dichotomous distinction between people with capacity of judgment and those without this capacity, and rejects the possibility that capacity of judgment of another could be partial, abolished, or diminished. The regulation does not allow the individualization of the measures according to the real needs of the person, and does not contain any measures to support the person in decision making process. They also criticized the phrases look after and interest in its content, that they are not defined, and it's not clear. In this case, also was formulated a request to recur to European Court of Justice with a preliminary question, but the Constitutional Court rejected as unfounded the request. The author of exception of unconstitutionality considered that at least 11 provisions of constitution were violated, and what is important that they claim also the Article 12 from the Convention on the Rights of Persons with Disabilities on equal recognition before the law, the convention which was ratified by Romania. The Constitutional Court held that the provision is unconstitutional, and it violates the Article 1, paragraph 3 of Constitution on human dignity, Article 16 on equal rights, Article 15 regarding the protection of disabled persons, and as interpreted in accordance with Article 20 of Constitution and Article 12 of the Convention of the Rights of Persons with Disabilities. The court stated that adjudication of incapacity does not take into account that the fact that there may be varying degrees of incapacity and the diversity of individual interests is not ordered for a specified period of time, and is not subject to regular review. The Constitutional Court also stated that an incapacity must not lead to the loss of the exercise of all civil rights, and must be examined in each case. Regarding to the effects of this decision, the decision was published on 27th January 2021. The effects of such decisions are that the normative are declared unconstitutional. Is suspended for 45 days from the publication of the decision. After 45 days, ceases to have any legal effects if the legislator does not bring the constitutional provision into line with the provision of the Constitution. The Romanian legislator has not adopted within the 45 days legislation regarding to adjudication of incapacity, which means that starting from 13 March 2021, adjudication of incapacity in Romania has no legal basis. As a result, all the requests having as objects adjudication of incapacity pending before the courts either was rejected or they were successively postponed. I doesn't have to explain what are the consequences regarding to the legal security of the involved persons. As conclusions, we can say that relatively few exceptions of unconstitutionality were raised and admitted regarding to the Romanian civil code. If we compare with the exceptions of unconstitutionality admitted regarding the other fundamental codes, for example, regarding to the Code of Civil Procedure and Criminal Procedure, Criminal Code, were admitted 12 exceptions, and regarding to the Code of Criminal Procedure 63. All these three fundamental codes are into the force from 2013 and 2014. The civil code enjoys a relative stability. It was just amended just by the law number 71 from 2011 on the implementation of the civil code, and by these two decisions of the Constitutional Court. The decision 534 decided about a very sensible question in the Romanian society, and we can see that the Constitutional Court shifted the responsibility to the European Court of Justice to decide about this question. The decision 601 from 2020 was absolutely necessary in Romanian law system, and means forcing the legislator to respect ratified treaty many years ago. I think it is very important to follow the practice of the constitutional and the Supreme Courts of in the other member states. I think we can appreciate the correctness of the solutions adopted by our legislator only by reference to practice of the other states and case law of European Court of Justice. I thank you for the attention, and I hope that I respected the time limit.